All right, we're about to start our landlord-tenant docket here in just a few moments. I'm never going back to my school.
Good afternoon.
Good afternoon. Thanks for helping Judge Pattison this morning. I was a little bit dismayed that that girl hadn't even bothered to contact you,
Oh, yeah.
but maybe you can help her.
Yes.
Oh, I'm looking at something. Did you do a case already for Amber Shelton?
Her name sounds familiar. Let me double check.
Well, you weren't here yet, but seems like we had 17. We had 2 cases in 20. We've had 2 cases in 20. So I think you guys did something in 2020.
Okay. Yeah, I wouldn't know about that because I don't see her in my database.
All right. She should be there. All right, now let me get ducks in a row here. We should go live here in just a moment. I'm never going back to my school. All right, looks like we're getting a lot of people to come in. Let's bring them in. We got Soltis, River Trail, Amber Shelton, and Maria Matson.
I'm sorry, what was that?
Ms. Shelton, welcome back. I brought you back into the courtroom. We are on the record. We're on YouTube. We're live on Zoom, and we're ready to go. Your manager is here from River Trail. Also, Mr. Robert Soltis is here, and we've got people in the next upcoming cases. But this is a third time or so we've been here on this defendant. We had a couple cases last year. It's titled River Trail versus Amber Shelton. The file number is 21450 this time. Mr. Robert Soltis of Kalamazoo Portage is here on behalf of the apartment complex. Ms. Shelton is here, and the manager is also here. What's the status here? Oh, first of all, I need to read you your rights again, Amber. I've done this a couple of times, but this is a new case, so I need to tell you your rights once again. I'm going to bring in Chelsea, who I believe is in Mr. Thornton's case. Chelsea Holman. Mr. Dick, can you take your hat off?
Oh, yes, sir. Sorry.
Is Chelsea there with you?
Yeah, she is.
I'm just outside holding my son so he's not screaming.
All right. Well, you guys have heard this before, but let me read it again. Ms. Shelton, this is for your benefit. As a defendant in a landlord-tenant proceeding, including non-payment of rent, termination of tenancy, land contract forfeiture, or other action, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have the right to a trial by a jury or by the court. If the action is for non-payment of rent, the Michigan Department of Health and Human Services, in our case Keystone, may be available to help you pay some or all of your rent. And we have a representative here with us today from Keystone. If a plaintiff is agreeable, the Citizens Mediation Services may be available as a possible source of case resolution. If the parties are interested, they can contact the court and we can facilitate that. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may have moved to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. So let's start with Ms. Shelton's case. Then we'll deal with Mr. Thornton's. He's got several. Ms. Sheldon, it appears you're behind in the rent once again. Mr. Soltis, what's the status here today?
Well, Your Honor, Ms. Shelton did drop off a $360 money order this morning, which reduces her rent owed to $640. And
Through April?
Through April, yes.
All right. Amber, what's your thought here?
That's right. I just got off a money order this morning, and now I know I owe April's rent.
All right, the law has changed a little bit. We got a new memorandum in fact, an order from the Supreme Court dated March 23rd that said now we are to set the non-payment of rent cases out 30 days. Keystone could be available to help you pay your rent. There is also the ability to ask for a stay of non-payment of rent cases until June 30th. But I used to adjourn these 7 days, at least 7 days, but now I have to adjourn them at least 30 days. So let's calculate the costs in there as well. We have $37.25 filing fee. That's the service fee. Filing fee is $55. Statutory attorney fee of $75.
$167.25 I have, Your Honor.
Plus $640.
$807.25.
Ms. Shelton, $807.25 would pay your rent through the month of April. Then, of course, May's rent is due May 1st. It seems to me in each case you've managed to come up with the rent. You got behind, and I'm not sure if you've even got help from Keystone, but Keystone is available if you do need some help. But because I have to go 30 days, I'm going to continue this. I've screwed up May 14th because we have a judicial conference the first Friday in May. So the second Friday is where we're going to do our criminal pretrial. So let's look.
No, if I have this paid up by May, I still have
No,
to
you
come
won't
to
need to,
court?
you won't need to be here. I'm going to continue this to May 14th at 1:15. And if you've paid, you need not appear.
Okay.
Are you still at the hospital?
Yes.
Okay. All right, let me recap everything I just did. I've continued this for more than 30 days to May 14th. I've told you that you owe $640 plus $167.25 in costs, which would pay your April's rent. That's $807.25. If you pay that, you're good through the month of April. Then you would owe May's rent of $580 on May 1st. Keystone is available for help if you need it. You could also get some legal advice. But if you simply pay the rent, the matter will be dismissed and then we start over again. That's what you've done in the past. And I'm fine with that, except it keeps adding court costs and attorney fees. So you've lived there for several years, 3 or 4, and hopefully you can maintain that. Do you have any questions?
No, I plan on paying April and May's rent,
All right.
so I don't have to work.
All right, that's fine. If you do, then they can simply file an order of dismissal.
Okay.
All right, you're good to go, Ms. Shelton. Thank you,
Your
Mr.
Honor.
Solis.
Thank you, Your Honor.
All right, we've got Mr. Thornton on a couple of cases. Well, let me see, I got messed up here. Oh, here it is. I got 2 judgments on page Ness and no judgment on home and land room, so I think we're out.
Yes, and Landrum, Your Honor,
Is dismissed.
is a dismissal.
Yes, and I got the dismissal and a judgment on that, but I don't have the judgment on Holman and Landrum, or Dick. Let's talk about that case. This is file 2, well, yes, I do have the judgment. Here it is. Apologize. 21416 LT. It's entitled Sturgis Place Apartments versus Chelsea Holman and David Dick. We were here on April 5th. Miss Emery was here with us also. And they did request some assistance. We continued the matter until today. Mr. Thornton gave me a breakdown today of costs and late fees through April is $2,354. I'm going to take out $120 of late fees. They're charging $100. I don't think anybody allows $100. I allow $40, which is $2,234.74. $2,234.74 plus $203 in court costs is $2,438.58. Is that correct, Mr. Thornton?
Yeah, I come up with $2,438.58.
All right. Mr. Holman and Miss Holman, Mr. Dick, what's your position? Did you contact Keystone?
Yes, Your Honor, we did. We have the application right in front of us, and we're in Keystone's apartment. We haven't been able to get to a printer because mine broke down, and her grandma works completely different hours than I do. And when she gets home, I'm already in bed for work. So my girlfriend Chelsea is getting the house key from her grandma today, and when she gets out of, like, when we're done and everything, we're gonna.
So you're at the Keystone parking lot right now?
Yeah.
All right. We know what the arrearage is. Now, this is the second hearing. Theoretically, I could just do a 10-day order from today. You did not request a COVID stay. You could still do that. Just download the CDC COVID stay. But because this is the second hearing, I'm gonna do the judgment. My hope is that Keystone can help you before that judgment comes due. Mr. Thornton, is that your preference? Would you rather I continue this?
It would be our preference, Your Honor, to just do the judgment. Hopefully they will get the help and it'll work itself out.
All right. Now, let me tell you both some things you need to know. Sturgis Place Apartments has been cooperative with the aversion eviction program. I don't know what I said, eviction diversion program. I'm not sure what I just said, but they've been cooperative with helping with the paperwork and getting it completed so they collect their rent and keep tenants in their places. But I'm not sure what happened. I adjourned this for a while and you didn't get there until today. I'm going to tell you some things you need to know. Through April, the rent component is $2,234.74. Costs are $203.84 for a total of $2,438.58. Theoretically, you have to pay that by April 22nd. That's 10 days from today. Partial payment will not prevent the writ of eviction. Acceptance of a partial payment will not prevent the eviction, and I'm not ordering any money judgment at this time. You also until have April 22nd to appeal this. Now, listen carefully. They don't have to evict you on April 22nd. They have 56 days from the day to ask for the writ of eviction. So you're trying to work with Keystone to get some help. I have every reason to believe that you will be eligible. Bettina is doing a good job, and the other ladies there at Keystone are helping keep people in their homes. But you have to get on your horse and take care of this business. The other thing that I'm telling you is you may have the ability to ask for a stay of eviction because of the COVID restrictions issued by the Michigan Supreme Court. And that would extend until June 30th, but you have to make a good faith effort to pay your rent. So I'm not continuing this, I'm doing an order. This is our second hearing. So you need to go to Keystone, get on the stick. If the rent gets paid, the matter can be dismissed. If it doesn't, they may ask for a writ of eviction, and then it's up to you whether you request the stay or not. So go inside, wear a mask, get what you need to do from Keystone, and get that paperwork started.
Yes,
Do you
Your
have
Honor.
questions?
The only thing that I need is my check stubs printed off, and I think they might be able to do it in there. I'm not sure.
All right, thank you.
We can do that here in the office here.
Okay, all right, thank you. I'll let you go.
All right. Thank you, Your Honor.
Okay. Mr. Thornton mentioned his other case, which was actually set for 125. We're a little behind, but not too bad. It's the matter of Sturgis Place Apartments, LLC versus Paige Ness and Greg Landrum. They're not present, but Mr. Thornton has prepared and forwarded a notice of dismissal. What's the status here, Lance? Did they move or pay?
They pretty much paid up. They owed a small late fee, but that was waived by the by Stoughton or Sturgis Place. And they are planning on moving, I understand, at the end of the month. Is that true, Maria?
That is correct. They are at a zero balance right now. The late fee has been waived. And they are moving at the end of April.
All right, I'll accept your dismissal and you're good to go, Maria. That takes care of your case. Lance has stuck with me for a bit.
Thank you.
Thank you. Are you on Green Valley, Lance, or is that? Yeah, you are. That one's set at 2, so we've got a gap in here, and we've got messy circumstance. Well, let me bring in Galaxy S10. She's getting close. She's trying to turn her audio on. Good afternoon. Could you unmute your microphone? You're all right. Very good. Who am I speaking with?
This is Sarah Sabin.
All right. Let me give you a name.
Sarah Sabin.
Yes. Let me give you a title here. Do you spell Sarah with an H?
Yes.
Not like Zach and Sarah with no H?
Yes, there's an 8.
All right. I'm going to bring the attorneys in. Good afternoon.
Good afternoon, Your Honor.
Andy, can you hear me?
Yes, sir.
We have a number of SAC financing cases set for today. I set them all in a big batch. Sarah Elizabeth Sabin is here with us. She is objecting to a garnishment. We're going to deal with that one in a minute. But we've got a bunch of SAC finance cases where Waiver and Olsees has filed pleadings, in fact, for judgment liens without ever doing a substitution of counsel. Attorney Rognus was counsel for SAC Finance for a number of years and was still attorney of record, and Waiver and Olsees started filing documents without being the attorney of record. So I set all of those cases for today. They include file 180513 SAC versus Kyle Babb and Catherine Smith. File 161022 GC SAC Finance versus Todd Moore and Rhonda Wolf. File 161249 SAC Finance versus Wendy Alexander and Jesse Booth. File 161583 SAC Finance versus Devin Shipe and Angela Shipe. File 161584 SAC Finance versus Tristan Marie Smith, Sheldon Ashbrook, and Michael Robert. SAC Finance Inc. File 161592 versus Mindy Kirby and Benjamin Early. SAC Finance Inc. versus Melissa Watkins and Jerry Watkins, 17184 GC. File 170233 GC. SAC Finance versus James Lego and Misty Rogers. File 171627 GC. SAC Finances versus Lori Webb and Joseph Morgan. File 18510 GC. SAC Finance versus Caitlin Poling and Joshua Jackson Lewis. Joshua Lewis Jackson. 1810511 GC. SAC Finance versus Eric Shank and Brittany Wallace. File 180720 SAC Finance versus Thomas Langston and Mary Beth Wells. Finally, SAC Finance 181513 versus Virginia Babcock and Dixie Tullis. Again, Waiver and O'Cease filed appearances, in some cases for judgment liens and other things, without a substitution of counsel. Mr. Rognus, I'm not sure what happened, but we can't just have somebody file an appearance when there's another attorney of record. Mr. Rognus, do you have any objection to that? Are you willing to substitute Waiver and O'Cease on all of those cases?
Yeah, Your Honor, these are old cases that we got judgments on years ago. These people were pretty much uncollectible. We were culling our old files, closed these and sent them back to SAC Finance. So, yeah, these are all closed files for us. We have occasionally gotten substitution of attorney forms, but I don't remember getting them on these 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 cases.
Mr. Bardo, what do you know about this?
Your Honor, obviously we didn't receive notice for any of this, so this is the first time I'm hearing about it. I'm not the attorney of record on these files. I will definitely have to go to the attorney of record to see what they've been doing on these files. I do know that pursuant to the court rules, an appearance is not infinite. I know that an appearance lasts until not only judgment is entered, but until the last appeals process has lapsed for the defendant. So whether that be, I think the longest one pursuant to the court rules would be 1 year. So 1 year after a judgment is entered, the attorney of record is no longer the attorney of record. And I believe I know if we filed a garnishment, the court rule states that a garnishment itself would constitute a first appearance for a counsel. So I know a lot of courts, I know the 36th District Court down in Detroit never takes the attorney of record out of the computer system. So when we do file something after that 1 year period, they do not like it and tell us that we need to do something other than just filing paperwork, because they need to switch that in their system. But I do know the court rules allow the lapse in attorney after 1 year of the judgment. But as to these,
well, then cite me a court rule. You're sort of speaking off the top of your head. We sent notices of all of these to Michael Cease, I think. Perhaps I'm mistaken. Anyway, I set all these for a day that you would be here. I can't tell which of these he has notice on, which he doesn't. At any rate, we have a record on these cases where the attorney of record has no objection to the new attorney appearing. And I can't tell from looking at these whether they got noticed or I was just going to deal with them today. So Mr. Rognus has agreed that Waiver and O'Cease may appear as attorney of record on those cases I went through and make notes in those files. We do have Kyle Babb and Catherine Smith, which is set also. So Andrew, I think that completes your obligation for those cases.
Okay, thank you.
All right. Then let's talk about the case that we do have, which is SAC Finance versus Sarah E. Sabin. Ms. Sabin is here. Mr. Zazan Barda is here for the plaintiff. I do appreciate it when you put your P numbers in your appearance. That's helpful.
I'm sorry, what?
Oh, I'm just talking to the attorney. Every attorney is assigned a separate number. P stands for professional. The oldest numbers, when everyone was an attorney, they just alphabetized them and gave them a number. After that, you're given a P number in order of your passing of the bar and admission into the state. Anyway, Ms. Sabin is pro per. This is an objection to garnishment, and it's a bit screwy. There was an installment payment agreement. This is a fairly substantial debt. Originally it was $5,774.47. I got an objection to garnishment filed by the defendant in the waiver of filing fee. Claiming that the installment payment order is still in effect, which it appears to be. I don't know that there's ever been an order setting the installment payment order aside. There was an installment payment order signed June 2nd of 2015. The defendant was to pay $150 a month. That's not a lot on a debt of that size, but the plaintiff filed a garnishment at Dollar General without ever setting aside the installment payment order. And so here we are. Mr. Barda, you've inherited all these files.
That is correct.
From Mr. Brogdon, back to you. What's your position here?
Your Honor, I would have no objection to the court granting the defendant's objection to garnishment if in fact the court is telling me there's a valid installment payment order in effect. The defendant also states that it's paid in full. I just want her to know, unless she can demonstrate to us, and as you said, this is a 2012 judgment. We got it in June of 2020. So any history on this file of payments, if she believes it's paid off, I need to know that immediately to file a satisfaction of judgment. I still show that $6,700 now due and owing, and that $1,536 of credits were given on this file. So
all right, say that again.
The total amount due is $6,701.36. Total payments were $1,536.05.
Can you say when the last payment was made?
Let's see. I cannot, Your Honor. I do not have the information.
Now, Ms. Sabin,
Yes.
You had an earlier, you were working at Summit Polymers, and this debt is quite old. If you have proof that the debt's been paid off, the original debt is $5,774. They claim you now owe $6,700. You owe more than what the original judgment was for.
Right.
And you're claiming that the debt is paid in full. I'm a bit suspicious of that claim, but if you have proof that it is paid in full, what do you have?
Well, Your Honor, I am still waiting for Highland Ridge for HR to find how we're going to get all of Adam's. Adam actually hasn't worked for Highland Ridge in the last 2 years, so getting HR to try to dig into those records has been kind of a challenge for me. But we
So
have
are you saying that they made the collections from Adam Cloth's account?
majority of them was paid through Adam. I was also curious as to how in June of 2015, in July of 2015, there was only a balance of 4,700 when they were trying to garnish Summit Polymers, in which I had lost my job. Then 3 years later, in 2018, when they started garnishing Adam, the balance went down $400. So to Summit Polymers, and then all of a sudden, 3 years later, again the balance is back up to $6,500. So, like I said, I'm waiting for Highland Ridge to be able to release those to me. This is an extremely old debt, and I just find it very odd that in 9 years we haven't been able to come. I mean, all the jobs I've had have been garnished through SAC. So I'm not understanding how the debt
Well,
is. I know
well,
that
the original.
I know that there's interest in stuff that grows. I'm totally aware of that. But I don't get how it goes down 3 years later with no interest building. But then again, 3 years after that, there's another $2,100 added to that.
Well, I don't know the answer to that. They're kind of fumbling in the dark. They got this file from somebody else, and they didn't file a substitution of counsel. They just filed an appearance and filed this garnishment without understanding that there's a valid installment order in effect. So when the clerk got this, she's like, well, what am I supposed to do with this? There's an installment payment order in place. So I set it for a hearing. So the ball is in your court. You're going to need to get information. Well, the problem is they say this much is due and owing. They don't know how much was seized from the co-defendant. They don't know how much was seized from you. There's a huge gap in time between when Mr. Rognus had it and when you had it. But you were under an installment payment order to pay $150 a month, and you haven't made a payment in years, I don't think.
No, I haven't. I mean, to be completely honest, after Summit Polymers, I ended up in a little bit of trouble. I did some time in Cass County. I spent 2.5 years trying to get clean from alcoholism, and where I did not work at all. But I have been clean almost 5 years, and I've had my current job in July will be 4 years. So to be completely honest, I have forgotten all about this SAC finance thing. There's a lot from my past I don't even really remember. Very sad, but I mean, I'm willing to at least do the installment payment until we can get those records from Human Resources.
The installment payment is in effect. It has not been set aside.
Right. Well, that's what
So,
I'm saying. I mean, I can continue to do the installment payment.
all right.
But the
Defendant to continue.
25% of my paycheck I can't do. That's my whole paycheck.
Well, I'm going to set aside what they've garnished. Well, do you want me to set it aside? It will reduce the debt, but they garnished you unlawfully. They garnished you while an installment payment order was in effect. But if we leave what they've garnished from Dollar General or wherever else, it will reduce the debt. So if you want me to just stop the garnishment henceforth, I'll leave it up to you.
Well, what will happen if we stop it, and then how much time do I have? Would I have to get all those records in place and turn them in?
Well, you'd have to start the installment payment on May 1st.
Okay.
The garnishment is terminated immediately.
Okay.
Effective today. So I'll do an order. The installment payment order is still in effect. I don't believe that this debt is paid in full. I believe that, I'm not sure I believe their number, but I'm not sure I believe your number. The number's somewhere in the middle. We also know how much was garnished from the co-defendant. And this action is only, the installment payment was only for you, not for him. So they could continue to garnish him. So I'm not sure how to do this. Make the plaintiff prove how much you owe, or make you prove how much you don't owe. He just threw a number at the wall and see if it'll stick. I can't tell what they garnished from Adam Clough, and there are garnishment disclosures in here, and you represented that it had been reduced to lower amounts.
Yeah, as little as $4,341.07. And that was in March of 2018.
Well, that's not too far away from his credit of $1,536. Then when you stop paying, the interest continues to accrue. So his number of $6,700 may well be the correct number. And if you stop making the monthly payments, they'll move to set aside the installment payment order and go back to garnishment.
But what I'm trying to say, Your Honor, is in July of 2015, there was only $4,738 that was owed. And then 3 years later, if the interest is supposed to grow to that amount of 65, which makes sense, but in 3 years' time, how did the amount go down $300 if it's supposed to grow interest in 3 years?
My suspicion is that they were garnishing Adam Clough's wages somewhere, right, and then no one has paid since 2018, and then the interest kicks back in, and the interest and it grows. I'm speculating here, but I think it's based on what I know. So let me repeat: the garnishment is terminated effective today. Plaintiff agrees. Your installment payment plan, which is still in effect, is $150 a month, which is quite low for a debt of this size. Your interest is probably close to $150 per month. You're going to be paying this till you're 117 years old at the current rate, but we set it at that, subject to review in 1 year. Plaintiff never asked for a review, and they never moved to set it aside, so theoretically it's still in effect. So I'm going to do an order. I've got your address, is the Topeka, Indiana address?
Yes.
All right, I'll do the order. And whatever information you can garnish or gather about who got garnished when would be something they would consider. My guess is their numbers are accurate or close to it. But if you can prove otherwise, in the meantime, you got to start paying $150 a month, and that will stay the garnishment. They could still garnish your income taxes, but they can't garnish your wages. Do you have questions?
I don't.
All right. All right, you're free to go, Ms. Saban. Thank you.
Thank you.
Thank you very much, Your Honor.
Well, we're not done yet. I think we got one more to deal with. I'm going to remove Ms. Saban. Oops, I won't do that one. The next matter is that set for today? set a hearing as to status of counsel and appearance. No substitution of counsel. This is the one that's actually noticed for today. SAC Finance versus Kyle Nelson Babb. That notice went to Michael Olsees, set for hearing today.
Is Babb spelled B-A-B-B or just B-A?
B-A-B-B.
What was the first name, Your Honor?
Kyle Babb and Catherine Smith. Notice went out to the parties. It was sent out March 18th. Sent to Kyle Babb, Catherine Smith. Those both came back. SAC Finance Inc., Andrew Rognus, and Michael Olsees.
And what was the? You have the address that it would have gone to Weber and Olsees?
Let's take a look. 3250 West Big Beaver Road, Suite 124, Troy.
Perfect.
Now, your appearance lists P.O. Box 3006, Birmingham. So I'm not sure why she used that address.
Yeah, we've done, that was our old office, but I think we're still getting mail because all payments that people still make, we're still getting.
Well, the appearance that you filed is P.O. Box 3006, Birmingham. I don't know why we sent a notice to Troy, but so no wonder you didn't get notice of it.
That was the address the system popped out. That's what we have as an address in the system.
Well, that doesn't work because their appearance has a different address. So he apparently didn't know about it, so no wonder you were confused about all this.
But there's a judgment lien in there, that's why I
yeah.
asked for that. Because they filed a lien and they weren't the attorney at record.
That was the particular concern. No, we should have sent it to the Birmingham address, but you filed a notice of judgment lien without being attorney of record. And that was why it caused the clerk some concern.
Okay. So moving forward, do you want us to file a substitution of counsel on all these files?
I would prefer it, or you cite your authority for filing an appearance. Mr. Rognus approved your appearance.
Yes. So on this particular case, what would the court like our office to do? I can do that right away.
Send an order saying that on the record, original counsel has agreed to a substitution by Weber and Olsees.
I can do that.
And I apologize. We sent the notice to the defendants at the last known address, and we just didn't use the right address to send it to you. So no wonder you thought I was from outer space. At any rate, I wanted to get him off the file, you on the file. We're always leery when someone's filing an appearance or filing a pleading without having an appearance.
Yes.
And that's what this was. So I set it for a hearing on a day that you were scheduled to be here anyway, except we didn't properly notice out to your firm. But that's what I would request. And in the other files, I will note that there was a hearing on the record where Andrew Rognus agreed to an appearance substitution by Weber and Olsees. So that should cover the 12 files we did earlier.
Thank you, Your Honor. And I will, can I just please have the case number for the one we're talking about? Just
Yes, it's, and I apologize, it went to your old address. It didn't come back. 180513 GC SAC Finance Inc. versus Kyle Nelson Babb and Catherine Leanne Smith.
perfect. I will send that order today. Thank you.
All right, thank you. We'll deal with you again. Thank you for coming to Centerville,
Thank you.
such as it was. All right, thanks. All right, now we're going to go back to our landlord-tenant matters. And we have Mr. Lance Thornton for Green Valley Apartments. And we have Ron Hughes and Lisa Jacobs. Mr. Hughes and Ms. Jacobs, can you hear me?
Yes.
Yes, sir.
All right. This is file number 21402LT. And the law requires that I advise you of your rights. Mr. Thorne, could you have your client take his hat off? Thank you. We are in a court proceeding, and there's a bit of decorum left, although not much, in these Zoom hearings. Mr. Hughes and Ms. Jacobs.
Yes, sir.
As defendants in a landlord-tenant proceeding, including what this is, a termination of tenancy, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have the right to a trial by a jury or by the court. If the action is for non-payment of rent, which this is not, Keystone could be available to assist you with your rent. Our local housing advocate, Keystone Place. If the plaintiff is agreeable, the Citizens Mediation Service, Inc. may be available as a possible source of case resolution. If both parties are agreeable to mediation, call the court to contact that and we can set it up. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment will stand. This is perhaps the most difficult type of case. It's sort of one thing and it's sort of something else. We were here on April 5th, and I gave you those rights last time, but I thought I'd give them to you again today. This is filed as a termination of tenancy action. They're terminating your tenancy not because of lease violations necessarily. The lease is simply up. And it's an expiration of the lease, and they want you to move. So in the old days, you'd get a notice to quit, and you got this notice to quit way back in November, saying they want you to move. You did not move, so they filed a complaint to take possession, and the complaint says no written lease, tenants are not paying rent and refuse to pay rent. So you have no lease, they want the premises back, you don't want to move because there isn't anywhere to move to. Termination of tenancy case does not allow for emergency housing funding because it's not filed as a non-payment of rent. They simply want the property back. Mr. Thornton, is that the plaintiff's position?
That's correct, Your Honor.
You guys had quite a bit to say last time. What else would you like me to know?
Oh, Your Honor, no disrespect to anybody. We didn't want to be in this situation. If he would have just simply talked to us last spring, we wouldn't be here right now. I didn't know all the events that were going to happen that's happened.
No, none of us did.
You know, I don't play only games I play are fun ones. Anyways, my father was living at the apartment building and stuff had got so bad, he moved away in 1 day's notice. I've been taking care of him since my mom died from cancer. Last 13 years. Stuff got so bad, he moved away to Colorado with 1 day's notice and left 99% of all my family's lifetime belongings, which Mark had gotten papers for and took possession of the apartment and has got all that stored down in a garage or something down there at the clubhouse. Anyways.
Well, did you move in after he moved out? Or you were already there? You were there and your father moved out?
It was a different apartment, Your Honor.
Yes, it was a totally different apartment. We've been with Green Valley Apartments for 10, 11-ish years. And I got volunteered. I took a volunteer position as greenskeeper. And a few months later, my girlfriend got offered the management position. And Reno Santori made a deal with us. He's ran Green Valley for the last 40 years. And he made the deal where I did maintenance at the apartments and Lisa did the management part. Because I've got PTSD multiple times over and high anxiety, and I just don't need any goofy stuff. Anyways, Reno knew that. That's how he set it up. Anyways, Mark decided to turn on the deal this last fall once he realized how bad my back was hurt. And he was wanting to sweep all this under the rug, and I didn't know what to do. I've never been in this situation before. No disrespect to anybody. I ain't trying to drag anything out. And last week, I did make a couple calls to get legal aid or help with Keystone. I did manage to get anywhere with the calls that I made. 3 days of last week, I spent fixing the door at the apartment. It got jammed up and locked. Somebody
Stop. Okay. Just a minute.
Mr.
Thornton, when was the last any rent was paid on this unit?
Your Honor, they haven't paid rent as long as they were managing it, but their management positions were terminated in October of last year.
All right, so you're no longer working there. So what do you want me to do? Just let you live there for free? You don't have a lease, you're not performing any services. They want you to move. Have you made any effort to find a place to move to?
We have made extreme efforts over the last months since notification. We've been all over St. Joe County, Branch, LaGrange, trying to find a place to move. We've lost all kinds of money on application fees and some other fee that had to be paid in order to be okayed for an apartment or whatever. Background check. Thank you. Anyways, we are currently confirmed on a place to move to, and we're not trying to drag anything out. We're awaiting a call. When exactly it is, we do not know, but we're hoping by the end of this month we're gone and gone forever. You know what I mean?
All right, well, let me ask this. Mr. Thorne, are you willing to extend this to April 30th?
Let me discuss that with my client quick, Your Honor.
All right, thank you.
Your Honor?
Yeah, just a moment. We can't talk while they're not here.
Right. Okay, sorry.
Autumn, is that you? September, is that you?
This is.
All right, I'm going to put you back in the waiting room. I didn't want you to think I forgot you, so stay right where you are.
Yes.
Your Honor,
yes,
our request is to just stick with the 10 days.
All right. You have until April 22nd to move out, or you're subject to being evicted. They don't have to evict you for 56 days. So if you say, hey, I've got a place to move on May 1st, they may not go through all the anguish to do an eviction. But this is the long process it took to move. And this happens a lot. People get to the 11th hour. They started asking you to move last November. You've not paid any rent. You've been there. It's now April. So you have until April 22nd to move, or you're subject to being evicted. They don't have to evict you on April 22nd. They have 56 days from today. You can also appeal this. I'm not sure what the reason would be, but if you can find a reason to appeal it. But they've followed all the steps. Now we had a first hearing, second hearing, additional delays. There's no lease. There's no rent being paid. And you have until April 22nd to move or file an appeal. Now, he may agree to give you longer than that if you're going to move, like I said, May 1st. They weren't agreeable to do an agreement. They were just simply wanted to stick with the 10 days, which is what we have. So you have until April 22nd to move. I'm not ordering any money judgment. And you are free to continue to request legal advice. Do you have any questions?
Yes, sir.
Okay.
While I was there at Green Valley, I went above and beyond. Anyways, I've done a $20,000 waterproofing on the whole apartment building, which is yet to have one leak. And that I did that the first year I was there.
All right, well, that's not a question. What's your question?
Oh, okay. I did over $60,000 in free roofs, and I was told by Mr. Mark Santori, the CEO, 2 years back.
Well, he's not here. This is a landlord-tenant matter. You're living there, you don't have a lease, and you haven't paid any rent. If you think they owe you money, sue them. You got 10 days to move out or be subject to being evicted unless they give you an extension. And I'm sorry, that's the way it is. I don't know about these things that happened years ago, and Mr. Santori isn't here. There are different owners. All right. Whoops. I put him in the waiting room. I put you in the waiting room. I'm going to send you a copy of this to your address on Fawn River Road.
Okay.
And you're good to go.
Well,
all right. I don't know what else he had to say, but I don't think it amounted to anything that was a defense.
Your Honor, you did have a judgment, didn't you?
I do. I've signed it effective April 22nd. Thank you, Mr. Thornton.
Thank you.
All right. We have an emergency hearing, but Tina, I'd appreciate it if you'd stick around here for a minute.
Yes, sir.
Ms. Knowles, are you here?
Yes, I am, sir.
All right, let's give you a name here. All right, this is an emergency hearing in the matter of Douglas Andrews versus September Knowles. We were here twice. Douglas Andrews is here on a video connection, and September Knowles is here by phone.
Correct.
We had a first hearing on February 22nd. You did not appear. You did call and said that you were in the emergency room. Then he said, I tried to call you and we couldn't connect, so I reset the matter for March 5th. You called on the 22nd and you said you just got out of the hospital. You were going to talk to Mr. Andrews and thought everything would be fine. I set it for the second hearing on March 5th. Mr. Andrews was present. You didn't show up. I think I tried to call you again and without success. So at that time, I ordered that you be out within 10 days. Mr. Andrews alleged that you were about $10,000 behind in the rent and that there's no lease. So I did the order. Well, just a minute, let me finish. So then you came to the court and wanted to speak to me, and I don't mind speaking with you, I never have, but I can't talk to you privately without the other party being there. So I asked the clerk to tell you to put it in writing. And so you asked for what I'm referring to as an emergency stay of the eviction. This is filed as a non-payment of rent case. He's alleging that rent is arrears north of $10,000. He represented, he simply wants you to move out. So what's your position, Ms. Knowles?
Well, with what you were saying, first off, his response was he had to put some number down. There's way more than just landlord and tenant. And I don't want to get you lost in the weeds, and I don't want to go far in depth with the situation. However, the situation is completely unfair. But Doug and I have communicated prior to this hearing here, and I have made an agreement and a promise to pay him a specific amount of $400 a month. And what he marked down on the last paper that I received was that I had given him $0, and that isn't true. I've given him.
Let me back up. I could never tell whether there was a relationship here or not a relationship here. But like you said, I don't want to delve too much into it. He simply said he didn't want you to live there anymore. But let me ask this. Is there a lease, September?
There is a lease, but it has no signature of my name on it. And there is also a written land contract in support of my child support case. But that was just in support of my child support case. So this is a huge, to be legally and to be brutally honest, this is just a shit show. And I want to continue to live here, and Doug has given me.
Let me back up. There's no lease.
I need you to be quiet.
When did you last pay any rent?
Well, I just gave him $1,000, but that was deducted from the $450 he let me borrow for a new iPhone, because it just is notorious that my
well, you paid him $1,000 when?
Not even a month ago, and I have another $1,000 for him, and I promised to give him $400, and he said as long as we can, reach a communication, and a promise and a $400 agreement monthly, then I can remain staying here. And that was just prior to this phone call.
All right. Mr. Andrews, what's your position? September, I'm going to mute your phone because you got a lot of disruption there.
I am.
All right, Mr. Andrews, what's your position? Mr. Andrews, can you hear me? Mr. Andrews? Bettina, can you hear me?
Yes.
Mr. Andrews, can you hear me? Which means he didn't hear anything that Autumn said.
Good grief.
Mr. Andrews, can you hear me? I'm going to remove him and have him log back in. September, can you unmute your phone? I'm not sure she can.
Oh.
A mess. I'm going to kick her out too. And have her log back in. She probably doesn't even know she's been removed.
I can reach out to her if you need me to.
Call her again.
Hello?
September, I need you to dial back into the court.
I am right now, sir. I'm on another line doing it.
All right.
Okay.
All right, September, can you hear me?
Yes, I can, sir.
Have you got someone to do something with the child? This is a court proceeding. Are people
I
watching
know.
it?
I'll actually go upstairs. I'm very sorry. Okay, is that better?
I don't know, but
He's gonna follow me.
Mr. Andrews,
Okay.
can you hear?
Yeah, I'm finally connected with you.
All right, well, September went through her whole story, and then I realized you didn't have your sound turned on, so I don't think you heard a word she said. In the meantime, her child started screaming, and I muted her phone, and then she couldn't get back in.
Yeah.
I kicked you out to make you start over again.
Yeah.
I'll try to recap what she said. This is a court proceeding. It's not a sitting around the table. September, can you hear me?
Yes, sir, I can.
All right.
There goes Lee.
I know, I'm going downstairs. Now he can't get down, and I'm down here on the bottom
I don't
floor.
want you to lock him in a room by yourself, but this is just emblematic of how chaotic your life is.
Exactly.
All right. Mr. Andrews says, I want my property back, or I want my rent. I'm not clear what the relationship is between you and Mr. Andrews. There is no lease. I don't know how much the money is. He guesses it's $10,000, I guess. So you didn't show up for the hearings. I entered a default judgment. Now you're indicating you've reached some sort of a off-book agreement where you're going to pay him money, you're going to get to stay there. She says she paid you $1,000 and she's going to pay you $400. Mr. Andrews, what do you say to that?
Yeah, she paid me $1,000. That was to pay back some of the money I loaned her, but I agreed on the $400 a month.
$450. You let me borrow $450.
Stop. You can't just shout out. It's bad enough we got crying babies in the background, but don't just blurt things out. I'll give you a chance to speak. I had this hearing just on your request, and I'm not even done telling you things I want to tell you, but don't just shout into the record. I'll give you a chance to speak. So in the meantime, you're loaning her money, you're not charging rent, you're charging rent, you get tired of her, you want to kick her out, you don't have a lease, you tell her she doesn't have to come. So what do you want, Mr. Andrews?
I just want her to pay rent right now. I mean, we agreed on $400 a month, and I'll go with that.
All right, then you need to set up a lease for
Okay.
$400 a month. I'm not gonna take any further action you file in this case unless
Right.
unless you have a lease. You
Okay.
got some sort of back pocket agreement with her where she gets to stay or she doesn't get to stay. When you get mad, you ask me to come kick her out. You need a lease. September, if you're gonna pay $400 a month, you need a lease that says
Yes, sir.
you pay $400 a month. I suspect the rent arrearage is close to $10,000. You've been there for months and months and months, you haven't paid rent. Then in the meantime, you're not paying rent, but he still lends you money. Then he asked me to kick you out. I don't know whether I'm coming or going.
Right,
so-
sir.
Go ahead.
If I could please speak, I have given Mr. Andrews payments. I paid for his drop ceiling on his basement. I don't want to go into details on things. I have contributed money. I paid my deposit when I first moved in. It's not like I've lived here for scot-free. I've taken him out to Fisher Lake. We've done things. He knows that I've helped and contributed. It's not like that at all. I do have the money right now for him, and I have given effort, which upon my absence doesn't give me any grounds to look good, and I understand that. But
you need a lease. Now let me ask this:
Absolutely.
Who's paying the utilities?
I have been paying my own utilities. They're in my name, and I've also contributed to the water bill, which isn't on the lease. If there was to be, I have paid, not every month, but I have contributed to the water, which is not included on the lease in this residency.
All right, you guys need a lease for $400 a month. I'm not going to take another action from you to terminate this tenancy unless you get a lease. Otherwise, I'll just do a termination of tenancy. The other thing, September, is if you had requested it, there's an ability to get a CDC stay until June 30th.
Okay.
And he couldn't do an eviction for non-payment of rent until June 30th. But this is he's filed these actions before. We start, they get dismissed. We start, they get dismissed.
Right.
And in the meantime, neither one of you got a lease. So he's telling me she's not paying the rent. You're telling me I did this, this, and this, and this, but you don't have a lease.
I have receipts and proof.
So you both deserve each other. There's no, I don't even know what the rent is. We have to throw a dart at the board and see if it sticks. But in point of fact, September, if you ask for the CDC stay, he couldn't evict you at all until June 30th. So what do you want me to do at this point, Mr. Andrews? Do you want me to simply dismiss it and indicate that you've agreed to set up a $400 a month lease?
I'll get a lease made out for $400 a month, and she can sign that. As long as she pays me $400 a month, that's all I ask.
And I will.
All right. Is that acceptable to you, Ms. Knowles?
Yes, sir.
All right. I'm going to recall the eviction order. The other thing is you need to show up for court, not a day later or a dollar short. I understand why you missed the first one. You were in the hospital. I don't know why you didn't come to the second one, or I wouldn't have defaulted you. I did even try to call you, but I wasn't successful.
Well, bless your heart. I appreciate that very much. I've had a lot of tampering with my mail here, so I've had to get a P.O. box. And even with my P.O. box, my keys are missing off the keychain. So it's been a tit for tat with a lot of BS. So I do apologize, and I have even said, you know, myself and two others, I know what you don't like, and you don't like a liar, and you don't like somebody that doesn't appear. I do apologize.
Well, I don't believe you lied to me about any of this. I don't disbelieve what you're saying, but there's just a disagreement. Well, but you and I have talked enough times. I guess you're right. You know what I don't like.
Yeah,
I don't
right.
like being lied. It hurts my feelings. but he agrees to a $400 per month lease effective May 1st.
Okay.
Mr. Andrews, you need to get a lease. In September, you need to sign it. $400 a month, utilities are in the tenant's name. Then if there's a dispute in the future, we can proceed from the lease. I'm going to recall the eviction order.
Okay, that sounds good.
And dismiss the case. And I will say, Autumn, that's very, or September, I keep calling it Autumn. September, it's very low rent. You're not going to be able to find a house for $400 a month. That's very inexpensive rent. So where are you
And we
working?
can adjust later on with rent. I was telling Mr. Andrews. However, I haven't gotten a penny worth of child support for my son that you hear in the background from David Apolloni. Other than him being bonded out, he's paid twice in my son's life, and my son's owed about $8,000. So things can get better with Mr. Andrews and with the rent situation. However, things are tight for me, and that's another battle I'm fighting. So.
The last I knew, he was in jail somewhere. Is he not in jail now?
I don't know. I saw actually Scott Moore yesterday at an outlet store, and he told me he was bragging about all this state help and almost $20,000 him and his new fiance were getting, but he hasn't contributed not even a birthday card to my son. So.
Well, I'll hold my opinion of that to myself. I wish what happened had never happened, and you two hadn't had a child together, but what's done is done. All right, now you're going to have a lease, $400 a month, starting May 1st. This case is dismissed. September, are you working?
Yes, sir. I'm actually going back where you go, River Lake, for right now until my Social Security number gets situated with the Social Security office there on Drake. I've had a lot of tamperism with my identity, fraud with my UIA and whatnot. So I got to work under the table right now.
Well, let me put it this way. I would like to go back to River Lake. It's one of my favorite places to eat. But I haven't been to a restaurant in about a year and a half, so maybe I'll see if the COVID situation relieves itself. All right, let me recap. The eviction order is withdrawn. The case is dismissed without prejudice. Parties are going to execute a lease, and any further hearings will be based on the violation of the lease. All right. Okay. You're both free to go.
Yep. All right.
All right. Thank you. You have a good day.
All right. Thank you.
Thank you. Bye.
All right, Bettina. I didn't know if that was going to come into the request for some money. That's a very difficult situation with the case being dismissed.
Yes.
So I'll do an order dismissing it, and I got to do an order in that other case. So thank you for your help. I won't see you for a while. You'll see Judge Patterson on the 23rd. I will be back on, I'll be gone Friday, and I'll be back the 27th. All right, thank you for your help as always.
Thank you. You have a great day.
All right, we have some 3 o'clock small claims matters. Maybe we can start those early. I didn't bring them in. All right, I've got Nate's note 10. Are you Nathan Smoker?
Yes, yes, yes. Yes, I'm sorry.
Could you take your hat off, please? Good afternoon, thank you. This is Judge Middleton. We're a little early, but we're here, and there's no harm in that. I'm going to stop the record and restart our small claims. We've been very busy this afternoon, but we're still moving ahead. All right, let me bring in the next dude. Let's see who this is. Let me first give you a proper name, Mr. Smoker. Let's see who LG Stylo 6 is. Good afternoon, sir. Can you hear me?
Yes, I can.
What's your name?
Devin Terry.
All right, Mr. Terry, let me give you a name. You're a little early, but there's no harm in that.
Okay.
We're going to just get started. This is Judge Middleton. I'm at the court here in Centerville, and you all are here for a small claims case. Mr. Terry, we are in court. It's okay to be in your driver's seat, but would you take your hat off, please?
Yep.
All right, Ms. Jean Teft is here on behalf of White Pigeon Township. She's the administrator there, and she files these actions quite regularly as small claims cases. Let me tell you both, we're in the small claims division of 3B District Court. As a rule in the state of Michigan, in the district court, you can sue for $25,000. And then beyond that goes to the circuit court. But there's a separate division called the small claims division where people can sue without an attorney. You can sue for up to $7,000. Neither party is entitled to have an attorney. There's no formal following of the rules of procedure or evidence. I'll allow hearsay evidence, but there's no appeal from small claims. Any ruling made here is final. If you wish to have it in the regular court, you can tell me that and I can remove it to the regular division of the court, but otherwise any ruling made here today is final. You understand?
Yes.
Yes, sir.
All right, Mr. Smoker logged in first, so let's do his. First of all, let me ask you all to please raise your right hand. You all swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
I do.
I do.
All right, we're going to do Mr. Smoker's case first, and Mr. Terry, just listen in because a lot of the same things will apply to you. This is a claim filed by White Pigeon Township for $532.16 as a result of invoices from the fire department for a vehicle fire. And I'm not exactly sure, that was in January of 2020. We have a lot of these. Ms. Teft is on top of them. Sometimes they're paid by insurance and sometimes they're not. This appeared not very far from the White Pigeon Township Hall on API Gravel Road. What's the status of this, Ms. Teft?
At this time, Mr. Smoker has not given me any money to pay the bill. And I would like to move forward with this to see if we can collect from him. And
right,
if he is interested in making an offer to make payments, I'd be interested in talking to him. But at this time, we had not made any connections. So I'd like to see if we can do something to settle this.
All right. Now, if we add in the filing fee at $41.15, the total amount owed is $573.31. Mr. Smoker, do you accept that?
No, I don't.
All right. What's your side of the story?
I didn't start the fire. It wasn't my vehicle. My claim is still being investigated, so they don't even know who started the fire yet. So why do I have to pay for the fire?
I guess my question is, sir, whose car was?
Stop.
Sorry.
Where did you take over? This is my court. I'll give you a chance to speak.
I apologize, sir.
Once again, we're not sitting at the kitchen table. So let's take a look at some of the pleadings. There was a report of a car fire. Heat from the fire had started to melt the siding on a home, and the fire department had to come out there. Whose home was it?
I was a friend. I was in between houses at the time. There was a friend I was staying at, Hillary Carper.
Fire appeared to have started in the engine compartment or near that area. Owner of the car on scene requested law enforcement as he suspects criminal activity. Yes. Owner of the car, Nathan Smoker, thinks it may be retaliation from a physical altercation that took place 3 days prior to the fire. Officer was requested but unavailable at that time. The fire was extinguished and everyone was instructed to leave the car alone until officers cleared the scene. The consent to search form was signed and the case was turned over to the White Pigeon Police and Michigan Police for investigation. There was very little dialogue on scene. Address given to Nathan Smoker as his boss's address. That's where he receives his mail. The car it doesn't say what the car is. Oh, it's a Mercury Milan. Who called the police?
I have no idea, sir.
Or the fire? You don't know who called the fire department?
No.
Ms. Teft, what's your side here?
My first question is whose vehicle was it? And my next question is, our firemen were on the scene to put out a fire that was caused by his vehicle, and I was told to send the invoice to him. So I had no choice but to do that.
Who owned the vehicle? Who was the registered owner of the vehicle?
My mother.
What's her name?
Shelley Case.
Say that again.
Shelley Case.
Where does she live?
White Pigeon. I'm not real sure of her address right now. I know it sounds like crock, but I don't.
All right, so this was 2/6. February 6th is a Thursday at about 1 o'clock in the afternoon. What's the story about the fire?
What was 1 o'clock in the afternoon?
It looks like this fire was at.
No, the fire.
Oh, wait
was
a minute. No, that's when she reported it. Let's see here. Well, I can't tell when the fire was.
It was like 3:30 in the
February
morning.
4th at midnight.
Excuse me, sir, I think you might be looking at something wrong because it shows here that I have the incident as of January 26th, 2020.
All right, let's take a look.
I'm looking at the actual fire report.
5:08 in the morning.
126, yeah, 4:56.
Yes.
All right, were you asleep in the house?
Yes, sir.
And then what did you know about the fire?
Somebody was knocking on our door, and Hillary woke me up. Went outside, and my car was on fire.
Did you make an insurance claim?
No, I believe my mom did.
right. Was there any further investigation of what started the fire?
Yeah, the Michigan State Police came there, and there was a bottle filled with, well, they think it was gas with a rag hanging out of it, and they found remnants of the glass shards in my front window, where my front window would have been, and that's all I've heard from it.
All right. Well, Ms. Teft, I think he may have, you never actually were able to contact him regarding the fire call?
I have not talked with him, sir. I thought maybe he might contact me and try to explain to me the situation, because I'm going by what is in the report here in front of me.
All right. Well, I can't tell. Let me look here. I don't think it says who the vehicle is registered to.
It said here the owner of the car on the scene requested law enforcement as he suspected criminal activity. So
Yeah,
I was going by the fact that the report said owner on the scene, which I assumed was Nathan Smoker, because that's who they told me to send the bill to.
All right, that makes sense, but I don't think he is the owner. They're going to sue your mother, is what they're going to do. And her insurance company probably would have paid it. The actual owner of the vehicle, as you're under oath, is Shelley Case.
Yes, sir.
Automobiles are different than regular property. If this was a piano or an expensive electric guitar or a piece of artwork or a lawn tractor or that sort of thing that got destroyed, question of who owns it may be a more open question. With a motor vehicle, the person that owns it is the person it's registered to. And so they haven't proven that you owned it, or that you caused the fire, or that you called the police. He says you requested law enforcement. It doesn't say you requested the fire department. They were already there.
Yes, sir.
So the matter is dismissed. Township sells shoe registered owner. Shelley Case. I can already hear what she's going to say. I don't know anything about this. I wasn't there. I don't own the car. My son had it. If it's registered in her name, then you're sticking her with a $530 bill. But
I promise it won't go like that.
What's that?
I promise it won't go like that.
All right. Maybe if she made an insurance claim, maybe they would pay it. All right, Mr. Smoker, this case is dismissed. By the court. And they can sue the registered owner of the car. My handwriting's so terrible. All right, you're free to go, and Ms. Teff will start over on her, and she does a good job of following up on these. But I don't find there's proof that A, it's your car, B, you started the fire, or C, you called the fire department, although theoretically you got some benefit by their appearing by having put this fire out. You also didn't own the house. All right, that matter is dismissed. You're free to go, Mr. Smoker. We'll try again. Okay. All right, now Mr. Terry's been waiting and watching. He's also under oath already and has been explained how small claims worked. You just saw this one. This is file 21345 SC, White Pigeon Township versus Devin Terry. This is a claim for $349.99, unpaid invoices for a White Pigeon Fire Department vehicle fire. Mr. Terry, what's your position?
I know I was in an accident on February 18th, 2020. And I'm not sure. I know the fire department and all that was called to the scene.
Yeah, this is the typical kind of thing they come out for, and there's a bill. So
right.
If we had $349 plus filing fee of $41.15, it's $391.14. Can you make some sort of monthly payment on that?
Yes, I can try. I had tried to get my insurance company to pay for it, but they are unable to. I'm not sure if it's because I only had liability coverage instead of full coverage.
Well, once they see this judgment, I would present it to them again. How much can you pay per month? Can you pay $50 a month? That would take 8 months to pay this off.
I can try to pay 50 or more if possible.
All right, I'll make at least $50 per month starting May 1st.
Okay.
Are you still at 207 St. Joe Street?
No, I am not. I've been meaning to contact someone to get my address updated.
All right, what is it?
It is 25039 West US 12, Sturgis, Michigan. It's 49091. And that's also going to be lot 119. Because that's at the Memory Lanes Mobile Home Park.
All right. All right. I think you already understood that you owed it. Try to see if your insurance company would do it. I would take this judgment into the insurance company and say, I got sued and they said I owed it. Will you pay it? If they do, great. White Pigeon gets their money. If they don't, you've got to pay at least $50 a month starting May 1st, or they can garnish your wages.
Okay.
Okay? Do you have any questions?
No, I don't.
All right. You're good to go. Thank you.
Thank you.
You have them out. All right, then the next one, I don't know if we got service, so I'll have to continue it. The next case we have scheduled is White Pigeon Township versus Alejandro Garcia Reyna. And it doesn't look like we were able to serve it. What do you know about that, Ms. Teff?
There was one that they said they couldn't serve, but when I spoke with the girls this morning, they said they couldn't remember which one it was. And I don't have anything here in front of me that says that they weren't able to serve it. So, of course, with the way the mail system has been lately, you never know. It could be in Grand Rapids somewhere.
Well, he's got a Sturgis address.
Yeah, I saw that.
But we weren't, no service, all right. Defendant, no show.
That was the same.
Yeah,
that was the same accident as the gentleman that was just in here.
Oh. Yes, Devin Terry. All right, we will reset, attempt to get service and reset. All right, that concludes everything we got for small claims. I'll just, do you have any other cases that you know are coming up?
I am going to file 5 more here shortly. The ones that I'm filing are because, you know, everything has been so delayed. So that's the reason why I've been doing it the way I have. So yes, I will be filing 5 more here shortly.
We'll see if we can set this guy at the same time. No, I understand that we got backed up in small claims. And
I know.
Just like everybody else. So we'll take them as they come. All right, that's all we can do today. You're good to go. Thank you.
All right. Thank you, sir. Appreciate it very much.
All right, that completes a very busy day once again. I'm going to stop the live feed because we aren't doing any more business unless we have some unexpected hearing that comes to turn us back on. Otherwise, we'll be here in the morning with arraignments and a very busy pre-exam conference day. And we have sobriety court in the afternoon.